Okay, good morning. Welcome to the third and last day of this BIAP workshop on factual statements and legal discourse. Now we have the presentation of Giovanni Tuzet. Giovanni is full professor of philosophy of law at Bocconi University in Milan. He has a law degree from the University of Ferrara in Italy and a PhD of law from the University of Turin and in epistemology from the University of Paris 12 in France. And he is, in my opinion, one of the reference authors in evidential legal reasoning in our Latin legal culture. And it's always a real pleasure to have you here. Thank you so much for coming, and the floor is yours for the presentation of the Can Machines Make Statements on Artificial Intelligence and Juridical Proof presentation.
Yeah, thanks very much, Jordi. Thanks. I'm very happy to be here. Thanks for attending this workshop. My title has changed a little bit. Now it's on AI and testimony. I want to focus more specifically on testimony rather than making a talk on juridical proof in general. Because the idea is to address the question whether machines can make statements before some fact finders, so if machines can make assertions that count as testimony in law. That's the issue. Of course, there are, I think, two ways of addressing that question. One is to go deeper into the conceptual analysis of the issues involved in that question. For instance, what do we mean by statement? What do we mean by assertion? What do we mean by testimony in general or in law? That's a sort of conceptual analysis of the thing, which is worth doing, I think. I'll say a few things in that perspective because I want to focus rather on the legal dimensions of the question. So I'll make reference to what some legal systems consider to be testimony, legally speaking, and whether we can take the outputs of an AI system as testimony is under some conditions. So I will focus on some legal matters at the end of the presentation. I think that the question I'm addressing is an interesting one, of course, given that I'm presenting my work on that. It's an assumption, of course, that is obvious. I must say that I don't have a strong and definite answer to that question, but I think that the most interesting thing that I can do now is to provide some considerations that help us finding an answer or some answers to the question. All right, so let me begin with a sort of introductory note. This is a very simple piece of a dialogue that you can hear these days. I mean, suppose that someone says, it's going to rain tomorrow, and the other asks, how do you know? Well, Alexa told me. You know what Alexa is. It's, according to Amazon's developer site, the Alexa voice service lives in the cloud. That's a nice way of putting it. It lives in the cloud. That thing is an intelligent voice recognition and natural language understanding service. It's also called an artificial assistant or something like that. It answers questions or commands. So you can command something and Alexa will perform what you require if it is in the range of things that Alexa can do. And it answers questions. That's the interesting thing for our purposes. And you can learn. I mean, that's the claim. You can learn from Alexa's words, okay? Alexa uses language, uses verbal it generates verbal outputs given your questions, and you can learn something from Alexa's words, like that, for instance, that tomorrow is going to rain. The interesting point is that, well, if you accept that, at least in a loose sense, the point is that Alexa has no beliefs at all. I mean, it's very weird to think of that system as having beliefs, nor intentions. I mean, there are no intentions in the artificial intelligence system itself. Of course, those who have designed the system and programmed the system had intentions, but the system itself has no intentions nor beliefs. So, in a way, the system makes statements, answers questions, and you can learn from that. It gives you information through verbal outputs, and you can learn from that. Okay, so apparently there's a way of saying that it generates also knowledge if the information is accurate and you have a justification to believe what you're told by Alexa. So in a sense, you can say that as a sort of testimony and a source of knowledge, even a source of knowledge, okay? That's a kind of starting point that I wanted to make. Now, just a few words on what we can take as a grand picture of intelligence. Sorry, I know this is very, very challenging in many respects. Let me just give you briefly an idea of a possible framework. I mean, you can put human intelligence in the middle here, and what we call reason constitutes human intelligence. And over the upper bound of reason, in the sense of human reason, human intelligence, you have what we call artificial intelligence. That's, I think, an intuitive way of putting it. For instance, Bayesian networks that have computational powers that are much greater than what humans have normally can be taken as forms of artificial intelligence that can be situated over the upper bound of reason. And there's intelligence which is below the lower bound of reason, which is animal, non-human intelligence. For instance, the intelligence that dogs have. They have hunting abilities that we don't have, that machines don't have. They have forms of intelligence that are different from our own. And yeah, so that is a sort of grand picture in which you can locate what I'm going to say. We can talk about this later if you wish. Now, about evidence and legal evidence. We are in the process of moving from some traditional tools and some traditional techniques to AI tools and techniques and devices and systems that help us in the process of fact-finding, help fact-finders collecting evidence, analyzing evidence, assessing evidence, and deciding on a case, right? These are some These are some examples of uses of AI in the evidence field. One thing that you are familiar with, at least some of you for sure are, it's probabilistic genotyping software. That's a thing that is much used these days. Other recognition softwares have to do with speech, speech recognition software or facial recognition software, object recognition software. These are AI systems that help an individual, a human person, attribute a speech to someone or recognize the face of someone or recognize a kind of object. I'll give you an example of this later. Textual analysis to establish authorship, that's another use of AI. Driving estimates from Google Maps, for instance, to check alibi. Or surveillance cameras that categorize what they see. They have some kind of perception, they categorize what they see and tell the police that's drug dealing or that's something else, that's a crime of some sort. And they communicate the information to police forces that can intervene in the relevant space and time. Okay, these are uses of AI in evidence, and concerning legal fact-finding more in particular, we can distinguish some aims for which AI can be used. First of all, to inquire about a case and collect evidence, okay? There are systems that help investigators do that. To analyze the evidence that you have collected, thanks to AI. To generate new evidence, that's the thing I want to discuss more specifically today. Generation of new evidence is an important and interesting thing. Then to assess the evidence presented at trial, it can be evidence that was collected independently of an AI system or evidence that was generated by an AI system that must be assessed. And again, an AI system may help fact finders assess the evidence presented, and then finally to decide on the merits. I'm going to focus on this and that, okay? First of all, let me say a few words on this, that is the assessment of evidence thanks to AI systems. This is, I think, a more common use of AI than the other one that I'm going to address. Let's take the obvious example of that. If you use Bayesian networks, you can have an assessment of evidence in probabilistic terms that is, this is the usual claim, better than human assessment in some respects. Of course, Bayesian networks work on some basic assumptions of Bayesian theory about probability, and the idea is that AI systems like Bayesian networks are much better than humans at determining, for instance, the a priori probability of hypothesis H, probability of H given background information, or the likelihood of evidence C, probability of E given H, and the a posteriori probability of H, which is what fact finders are most interested into. So the probability of H, of hypothesis H given evidence E. The idea is that machines, let's say like Bayesian networks, do much better than humans in that. Then, of course, you need a standard of proof to make a decision, because the evidence assessment process doesn't give you a decision. It tells you what the value is of the evidence, and then you have to make a decision considering the standard of proof. Well, we are familiar with that. Need not go into that discussion more in detail. Let me just say that traditionally in law, standards of proof are given a qualitative formulation. Beyond reasonable doubt is a qualitative formulation. Well, can be criticized because it's vague to some extent, it's ambiguous also, maybe. It's not sufficiently precise, and therefore, if you like that idea, that sort of critical idea, you may have the inclination to think that it would be good to quantify to some extent the standard of proof and give a quantitative formulation of that. But I'm not going to discuss this. Now, let's focus more specifically on testimony in law. So, AI can be used to assess testimony. That's, I think, the more common use of AI as for today, but also to generate testimony. And that's the new frontier, I would say, the thing that I want to address in this presentation. The generation of new evidence by AI systems. So the generation of possibly some testimony by AI systems. This is an example of what people have used to do in the last decades. For instance, David Shum has done some work on the establishment of reliability of a testimonial source. For instance, let's take the claim that a testimonial source is 70% reliable. What does that mean? Well, one idea is to say, well, we could measure and should measure dimensions like W's veracity or truthfulness. We should measure also the witness's objectivity and the witness observational sensitivity or accuracy. That gives you a measure of the reliability of the source, and you can apply that more specifically to a given testimony by a certain testimonial source and establish what the lawyers called the credibility. There's an interesting discussion about the possible difference between reliability and credibility, but I leave that for the Q&A if you wish. That's the more standard use, I would say, of AI with respect to testimony. Which has some advantages and some possible drawbacks as well. The assessment of a testimony by an AI system has, for sure, one advantage in terms of efficiency of the process. It's time-saving, is less costly than a human assessment. There's no fatigue of the fact finder involved because the machine has no fatigue, so that's an advantage. And there are no biases. That's interesting. That's an interesting point. There are no biases in the evaluation of a specific testimony in the sense that the system, there's no impact of sex, race, age, profession, etc. of the source. Unless the system is designed in a way that it incorporates a bias, of course, but that's another story. I mean, the idea is that the system has no weakness in that respect, and we as humans have that sort of, vulnerable to that, okay? But there are, of course, some drawbacks of that assessment. The first is that there can be biases in the algorithm or in the input data or in the way the system is designed. So, well, you don't have biases in the operation of the system, but you can have biases in the system as it was designed, of course. And the system can be opaque. It's usually opaque. That's the other problem. And in particular, there can be opaqueness with reference to the choices of the relevant reference class when you have to estimate the reliability of a source. Take this illustration of the point I'm making. I mean, this is the well-known reference class problem that is discussed in the literature. I want to make a reference to that with respect to testimony. What does it mean to say that the source is 70% reliable, for instance, when someone says, oh, that's the value of that testimonial source? Well, a possible answer is that in all possible conditions, source tells the truth 7 times out of 10. Well, or more specifically, in all accident conditions, let's assume it's a tort case, there was an accident, and so we want to establish the reliability of the source with respect to accident conditions, not just any condition, any possible condition. So in all accident conditions, source tells the truth 7 times out of 10. Well, maybe that's not specific enough because the accident occurred at night. So in all night accident conditions, blah, blah, blah. Is that sufficient? Well, maybe not. In all night accident conditions with rainy weather, etc., etc. So what is the machine going to tell you when the machine tells you that the source is 70% reliable? If the choices of the reference classes are opaque, you have a problem with that. Now, let me go to the point that I want to discuss more specifically, given the background that I've just presented. I mean, what I want to present now is what I want to address is the question whether machine can make statements and can generate new evidence, testimonial evidence that can be used by fact finders, okay? This is a sort of reformulation of the traditional question that many philosophers and computer scientists and other people have asked, that is, can machines think? That's the classical question, maybe an hopeless one. A reformulation of that is, can machines make statements or can machines make assertions, okay? That is the question, and one way of addressing that is to say, well, they are not exactly the same thing, but they are similar. So you can take statements by machines or AI systems, to put it better, as analog to human statements. So, well, there are some differences, of course, between an output by a machine and an output by a human being. A verbal output by a machine that uses language and a verbal output by a human being. Well, there are some differences, we can discuss about the difference, but still there are also some similarities. So you can take that as a sort of speech act, an assertion, making a statement, similar to what humans do. Okay? And the interesting point is that, to some extent, machines or AI systems can generate new evidence by doing that. Note the analytical difference between these two sorts of information. One thing is information stored in a device and presented as evidence. For instance, pictures that are stored, photographs that are stored in a device in your cell phone, and you show the picture and say, look what happened, I have a picture of that. That is information stored in a device, can be presented, it's going to be evidence, of course. It's not generated by the machine, it's not generated by the system. Well, in a sense, it's generated because without the machine you cannot take the picture, but it's different from additional information that is generated by a process developed by the device itself, okay? If that is possible, and I think it is what we call nowadays generative artificial intelligence. So artificial intelligence that generates new things, and in our context, new information that can count as evidence in a trial, okay? We can call it machine testimony. That's a phrase that you can find in the literature. There are papers that use this phrase that I'm going to use as well. And the idea is that machine testimony is a result of machine learning and questioning. So the machine learns, the machine is able to learn, and the machine is able to answer questions. So you question the machine gives you outputs that count as, for sure, information, and possibly also as they count as statements, assertions, and testimony in a legal sense. Two examples of that. Real-time object recognition software. You remember when I gave you a list of uses of AI in evidence, I made a reference to object recognition software. That's an example. A real-time object recognition software used by the police with body cameras telling the officer whether a gun or, for instance, a smartphone is in the suspect's hand. So that's a real-time thing, information that is given by the device to a police officer about what is in the hand of a certain individual. You can take that as merely information output provided by the system, or you can take that as a sort of statement. The machine is telling you, look, that person has a gun in his hand, okay? And that would count as a testimony of the machine. Or similarly, lip-reading algorithms that tell fact finders what was said on video where there is no audio available. You see the persons, you don't hear what they say, but the AI system can help you reading what was said. Now, a scholar that I'm referring to in this respect is Andrea Roth, that has published a very, very nice, very interesting paper on machine testimony, and I'm referring to that work also because she presents a case that I'm going to discuss briefly now. That's an American case of 2015, US versus Lizarraga Tirado. The case is about a person that who was arrested near to the border between the US and Mexico. The guy was Lizarraga Tirado. Paciano Lizarraga Tirado was arrested and charged with illegally entering the US. He admitted that he was arrested in a remote area near the US-Mexico border, but claimed he was arrested in Mexico by US police officers while awaiting instructions from a smuggler. So he admitted that he was planning to perform some illegal activity, but the point is that the arrest was legal because it was in Mexico. Now, a police officer, testified the following, testified that she used a GPS device to determine their location by satellite, And then inputted the coordinates into Google Earth. And that was the answer of the system. Look, these are the coordinates. We are here. Here's the border, United States and Mexico, here. So we are in the US territory and jurisdiction. Okay? That was the information given by the police officer. And now, and the police officer told the court that and provided this, this picture to support what was said. And the interesting argument of the defendant, of the lawyer of the defendant was, well, let's analyze what's happening here. Google Earth placed a digital tag on the map labeled with the coordinates, what I've just shown. No, sorry. Okay? That's a tag with the coordinates indicating that the location lay north of the border. Fine. And then the defendant has this argument, oh, it's hearsay then. It's hearsay, so it shouldn't be admitted. Because it's out-of-court assertion offered for its truth, and thus it's inadmissible, according to the Federal Rules of Evidence, US law about that. I'm going to tell you more about this in the next slide. Now, what's the response of the judge to that argument? The Ninth Circuit acknowledged that the digital tag was a clear assertion. They say that. The judge said, it was Judge Kosinski, if I remember correctly. He says, it's a clear assertion. No doubt. That's a very, very, surprising attitude toward that. Such that if the tag had been manually placed on a map by a person, it would be classic hearsay. Why is that? Because legally speaking, he was referring to Federal Rule of Evidence 801 that provides these definitions. It defines a statement as a person's oral assertion, written assertion, or non-verbal conduct if the person intended it as an assertion. So oral assertion, written assertion, or just a gesture or conduct if it is intended as an assertion. The declarant means the person who made the statement, notice person. And hearsay means a statement that one, the declarant, does not make while testifying at the current trial or hearing, so it's an out-of-court statement. And the party offers in evidence to prove the truth of the matter asserted in the statement. So given this definition of what we are concerned with, the argument of the defendant was, well, that thing that you are saying is hearsay, because you are referring to what the machine asserted. And that's an out-of-court assertion offered for the truth of the matter asserted. And since it falls under that definition, is not admissible. Wow, so what's the final decision of the judge? The court rejected the argument, which is again surprising because at the starting point they say, well, it's a clear assertion, so you expect that they're going to say that's hearsay, given the legal definition. But then they make another move and they say, machine assertions, although raising reliability concerns, are simply the products of mechanical processes and therefore akin to physical evidence. A clear assertion, which, by the way, is akin to physical evidence. Was that correct? It's a bit confusing, sounds a bit contradictory in a sense. It's a clear assertion, but it's akin to physical evidence because it's a mechanical thing. I have the impression that that sort of legal response is confused and confusing because it's kind of, there's a sort of contradiction in that. So I wonder what you think about this kind of response. So apparently what they say, what the judge was saying in that case is that the Google Earth tag was an assertion but was not hearsay because it was mechanical or automated or akin to physical evidence. Some commentators discussing this and similar cases say, well, we should get rid of that sort of discussion and treat that kind of information as expert evidence. If you treat that as expert evidence, you need not discuss the hearsay problem. You don't have the problems that you have if you treat that information as lay testimony. If you treat that as expert evidence and expert testimony, then everything becomes easier from a legal point of view. Maybe. I have some thoughts about this. I'll leave them for the Q&A. So that's an example in which the output of an AI system is treated as testimony, could be treated by testimony, but the court refuses to do that, even if the court says that it's a clear assertion. Now, in the legal discussion about this, there are claims about the possible safeguards for criminal defendants in particular, given the possibility of machine testimony. If we admit a trial machine testimony, there are problems and possible dangers for risks for the criminal defendants. You can consider them as classical black box problems, if you want, and the law is supposed to provide some safeguards for criminal defendants. For instance, the law can establish some operation protocols of machines, of AI systems that can be used only if they meet some protocols, or you can establish some pre-trial disclosure and access rules. You should disclose your information provided by a machine. You should give access to the functioning or operation of the machine to the other party. There can be authentication and reliability rules. And also, that's the point I want to discuss, courtroom testing rules. You should give the possibility to the defendant, to a criminal defendant, to test machine testimony before the fact finders. There are also possible corroboration rules and jury instructions and judicial guidelines. Let me focus on courtroom testing rules because it's, I think, the most interesting aspect if we wonder about the question I've been addressing here today, that is, can machine make statements? Consider the Sixth Amendment to the US Constitution. It says that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. That's a safeguard for criminal defendants. It's a safeguard that we can consider as a courtroom testing safeguard. You are going to put the testimonies against you under some testing process with cross-examination, for instance. And according to the amendment to the US Constitution, you have the right to be confronted physically with the witnesses against you. What does that right mean if the witness is a machine? What does it mean to be confronted with a machine physically? You have the thing there. What do you do? I mean, it doesn't sweat, it doesn't have emotions, so what do you do in that sense? Or similarly, take the European Convention of Human Rights, Article 6, Paragraph 3, letter D. Everyone charged with a criminal offense has the right to examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. Again, what does that mean to examine a machine or to have the attendance of a machine? Of course, these safeguards are thought traditionally for human witnesses, being physically present and as human beings with emotions and blah, blah, blah. So what these safeguards means if we have machine testimony? What do those rights mean with respect to machine testimony? If we have outputs by a machine or by an AI system that count as legal testimony. What does it mean to have confrontation with an AI device, or attendance and examination of an AI device, or cross-examination of an AI device? As the cartoon says, Your Honor, the witness is refusing to answer my cross-exam questions, of course. So when you have ex parte computerized production of evidence, these rights mean probably very little. So there's a problem here. There's a legal problem. The EU is going to enact what is called the AI Act, maybe in the forthcoming months or this year, I don't know. There are drafts of the Act circulating. The general approach of the Act is to distinguish some possible risks involved in the use of AI in trials, especially in criminal trials, of course. And that risk-based approach categorizes risks with in four categories, in fact. There is what is called unacceptable risk, that is forbidden use of AI. I'm not giving examples in the sake of time. There is high risk use of AI, which can be addressed with securing ex-ante conformity with some standards provided by the law. There is limited risk, which only generates a transparency obligation. If the risk that is involved in the use of an AI system is just limited, those who use that device just have the obligation to be transparent and explain and show how the system operates. And then finally, there is low risk that involves no specific obligations. That's the framework. I mean, we'll see what the European authorities will decide in the end, but apparently that risk-based approach will remain the fundamental framework of the regulation. Now, if we have machine testimony along the lines I was suggesting, which is the risk for criminal defendants? My intuition is that it will be something between high risk and limited risk. It's not unacceptable risk. It's neither, nor is it low risk. It's something like high and limited risk. If you categorize that as high risk, you need to have some ex-ante conformity assessment, some protocols, some rules that the system must comply with. Or if you categorize that as limited risk, you just need transparency. We'll see. That's for a future discussion. So summing up, I think I am, in time. I've been discussing some possible uses of AI in fact-finding. I've been discussing especially uses of AI in evidence assessment and decision-making. You can assess with AI systems the value of testimony in law. It has advantages and drawbacks. And more in particular, you can also generate new evidence with AI systems. And if you buy the idea that there is machine testimony, you can take that as testimonial evidence that is generated by an AI system. But then you have some legal issues, like, for instance, the argument that it's hearsay if a human being is telling you what a machine said. You have the issue of confrontation, cross-examination, etc. And that's the new frontier, I think. If we focus now on cross-examination, on machine questioning, it's the new frontier. What does it mean to question an AI device, to confront an AI device, and before fact-finders, before a court? So that's the end of it. As I told you at the beginning, I didn't answer, honestly, the question, but I hope I provided some considerations for elaborating an answer to the initial question. So, thanks.